which is basically, this is going to be how to really, if you are in business, obviously learning about law and where you stand really is very vital. So please, you're very well welcome to Joe Rogers.
Thank you, Matt. I feel like I can come away from the podium now. So hello everyone, as Matt said, my name's Joe and I'm the founder and CEO of NaviStar Legal. Thank you so much for coming this evening and thanks Matt for having me. Particularly as it's cold outside, and when I first heard about interesting talks, Matt was like, oh, you can have a look at this video, this is the sort of talks that we do. And he sent me this ex-madam, and I was like, an ex-madam who was doing like a really interesting talk, and I was like, So I have to warn you, if you're here to see an ex-madam, or if you think this is going to be really sexy and glamorous, I hate to disappoint you, but this is a pretty safe subject. It's pretty dull, and I'll make it as sexy as possible. But this is, you know, it's pretty foundational. How many of you guys are in business at the moment? So everybody, and that's what I would expect. You only really come to a talk like this if this is going to be of use to you. So let me give you a bit of a background to what I did. I set up NaviStar Legal 2 years ago now. Well, I actually stepped out properly a year and a half ago. And prior to that, I was working in the city. So I was working with buying, selling, listing. I raised over $500 million, not personally myself, $500 million worth of investment on the stock exchange. I worked in the corporate world. And I had no sense of the small business community. It was only when I left there in 2009, bottom of the market, that I started working for small businesses. And I realized that unlike the corporate world, small businesses resent paying a blank check to their lawyers, funnily enough. They resent actually paying anything cash-wise that they can do themselves. And so, as a small business myself, now, I'm on a mission to create affordable wisdom for small businesses. And that's what we're doing at NaviStar Legal. So you'll see my business card at the back and some leaflets, which are basic information. But really what I want to do is give people some simple guidelines that they can implement in their business, some systems that they can actually use in their business, some tools to make things a little bit safer. So that's what I want to do today. What I would like to understand from you guys is what it is that you want to get out of today. I've got a little flip chart. And you can shout it out, but I do want to make sure that, particularly as you're in business already, I want to just understand what are the issues that you're coming up with, or what are the things that you would go, what I'd really like to understand is this. What I will just caveat is that I probably won't be able to answer any specific legal issues during the talk, but I do encourage questions that are for the benefit of the whole. So why don't you let me know why you're here and what you want to get out of this evening, just by shouting out. Yes? Branding and copyright. Okay, anyone else?
Contracting,
Subcontractors. Okay, fab.
Particularly competition clauses.
Non-compete.
Yes.
Yep. Yep. Anyone else?
Internet stuff. I've been rather woolly about this. But,
Internet stuff.
What one's liabilities are if one's doing, for example, therapy online.
Oh, okay.
Skype or something like that.
So, issues, I guess there's two things there. One is therapy, and the other is the internet and what that brings up, because I think they're two different issues. Anyone else? Yeah?
Disclaimers on emails, how relevant are they?
Disclaimers.
And maybe licensing, licensing some of the image for a certain purpose. Or
Image or licensing generally, so...
Maybe, or an image, and then licensing.
And then generally, yeah.
Intellectual property licensing.
It's a bit of both. Yeah, licensing is usually because there's a right that you're able to license out. So, okay, anyone else? Yes?
Contracts with resellers.
Contracts with resellers and partners. Okay. Anyone else? Yes? T's and C's. Okay. No? Fabulous.
You mentioned something in this data protection obligation.
Data protection obligations.
We've got mailers.
Yes. I'm going to call those obligations just because that's what it would be, data protection. And mailing. Okay, fabulous. Oh, more. We only have an hour and a half, but yeah.
Employment contracts.
Employment. Yes.
When do you absolutely need to call in a lawyer rather than doing something?
Oh, that's a great question. Okay. Great. Well, what I'm going to suggest you all do, I'll take notes on action points to implement, because there's no point in coming to a talk. I mean, I do it all the time. Go to a talk, I learn something, and then when you don't implement something, you haven't learned the lesson. So I think it's just in putting some action points on paper, and we'll just ask some of those questions at the end. What points of action are you going to put into place into your own business that are relevant from what we've talked about? I also will be going for drinks, so if there are particular things from this that we don't cover, I'm happy to answer them afterwards. So, what do I think I'm going to give to you today? Hopefully I'll give you all of this, if not a broad section, because this is going to be quite a general talk, but I will hope to bring each of these issues into here, into the talk. What I hope to give you is some affordable wisdom that you can take away. What I won't be giving you is a law degree. So like there's a lot in this that I could put together, but you know, it took me 7 years of practicing to learn it. So there's no way that I'm going to manage to get it all into a short space of time. What I will attempt to do, as I mentioned before, I'd love to give you an opportunity to ask questions, but as I said, let's be careful that they're not too specific, because otherwise not everybody gets value out of the questions that are being asked. But at the end, we'll have a specific amount of time for questions, and we'll make sure that we address everything that we can. Okay, so the way that I have put this talk together is that I have decided to do 6 principles and 7 areas of business. And I think we start with the great acronym lawyer. Okay, so what I know about business, law. This is one of my principles of law, and what a lawyer is for, or what applying some of these principles are for. The intention is that you have less loss. You are likely to have losses in business, and the idea is that you want to reduce those as much as possible. You want to mitigate the losses that are possible with the work that you're doing. So let's say you've got a contract in place, or you've got a license in place. You want to make sure that someone can't just take that and ruin your reputation, for example. You want to protect yourself from certain things. The thing is about loss is that there are particular consequences. So there are particular consequences that happen as a result of, you know, the interactions that you have with someone, and it's all to do with the likelihood of the probability of something happening and the consequences as a result of them happening. So one thing that I'll get you guys to think about is what losses are possible in your business. For example, a loss in a business where you have the main breadwinner who is supporting 3 children is likely to be higher than someone whose business is just a hobby, because they have more to lose. The likelihood is just the same if they're in the same business, but they have more to lose. And so it's more important for them to minimize their losses and mitigate their losses in that context. Does that make sense? And I know that that's a really basic principle, but a lot of people think that law is about getting your losses down to 0. It's not. It's about less loss and less probability of that loss. And it's about thinking it through the opportunities that arise in order for that loss to occur. The second one is about attitude. This is a simple principle, and it's a basic business principle. But again, people have this misunderstanding with law that it's about being in court and being litigious and really fighting for everything you can get. Or one of the things that I found was particularly key with small businesses is like finding loopholes. In some way they think that you've got to find these loopholes in order to get around the law. That's not the case. And actually having an attitude of the win-win attitude and knowing that you're always going to be working with someone as a partner is a key principle in working in the law and working with contracts and working with any of this stuff. It's not about, well, sometimes it's about finding a shortcut, but it's all about the relationship and making sure that that relationship remains and focusing on that as the key element of business. So that's just another short, quick principle. This is one of the most important, and this might be something Orange need to learn. The third principle for me is a really key one. Write it down and keep it. So what do I mean when I say write it down? Well, there's several things you can write down. So for example, if I have a phone conversation with somebody, I record the date, the time, and the details of that conversation, particularly if it's in a business context. If it's in a personal context, there's no necessarily a need. But in a business context, you want to have those written down. Why? Because it forms a contemporaneous note. And if there is litigation later, then you have a record of what was said and the details that you thought at the time. The second principle then is, once you've had that conversation, sending an email to that person to confirm your understanding. Why is that? Well, because that's to get the detail and the understanding to make sure that you and I are thinking about the same thing. You can avoid a lot of issues when you are very clear about what it is that both parties expect. Write it down is really important. Getting an agreement in writing is even more important. But tell me this, how many people think that an agreement is only legally binding if it's in writing? No. Right, absolutely. It is always legally binding if it's an oral contract. It just needs to have certain things there. So why do we say get it in writing? Anyone?
Easier to prove.
Easier to prove. Evidence, that's exactly right. Anyone else?
You've got the detail there verbatim as well. So.
Yeah. And you can prove that both parties have signed up to the same thing. So for me, it's always a matter of evidence. What has that party actually said? What did I say? What did you say? It's all in that agreement. What's really important in writing an agreement, what will always be, and I suggest that you look for it in an agreement, is a sentence that states that any other discussion between the parties is not counted as part, so that everything in that agreement is part of the agreement. And just having a look for that one statement, particularly if you're diligent with the agreements that you're putting together, that'll be really helpful later on if they say, yeah, but wait a minute, I've got an email that said you do this, this, and this. No. This agreement is the agreement, and that is what the entirety of the agreement is. So that's really important, writing it down. I would also say keep all emails. How many people don't keep emails? How many people throw them away? Particularly in a relationship where you're in negotiations with parties, keeping those agreements are evidence of what was intended if you don't end up signing an agreement. But for example, you might start doing some services. You might say, oh, no, don't worry, we'll sign it later, which I can guarantee this is one of the biggest things that I would see with small businesses, and that is they go, oh yeah, we've got an agreement. Have we got a signed version? No. And the signed version gets to show that will show the details, or that will, if you don't have a signed version, then the emails will give a good indication about what is actually agreed. Yes.
What's a verbal agreement? What's an example of a verbal agreement being binding? I agree with your partner or...
Sure. Now, the question is, does that have enough detail in it? So if we shake hands and then I start working from your offices, have we got an agreement? Potentially. And this is where you need evidence, and you show, therefore, that you've got an agreement and that both parties have agreed to it. What you don't want, I had an example last week, and by the way, whenever I tell a story about any clients, know that I have, I'm not breaching any confidentiality. I will twist the facts somewhat so that you know I'm not just suddenly throwing out stories. But one of my clients, for example, had an agreement that said it was non-binding. But one of those parties, even though it said it was non-binding, it had enough detail in it, and one of the parties had given money, as it said they would in the agreement, and therefore there was an argument. Is it actually legally binding? Maybe. Do you want to argue that in court? Probably not. So from your perspective and from your side, making sure that you have everything tied up and you've got all those loose ends together is really important. And writing it down and keeping it is the key. Making sure that your records are amazing. Tell me this, how many of you guys know what your exit will look like? Do you know what in the future you might want to do? Do you want to sell, buy, list your company? Anyone? You know, okay, so there's a few people that know. We'll come to exit in a minute because an exit strategy, exactly. Everybody should have an exit strategy because you are going to exit your business at some point. The reality is it might not be intentional, but you are going to exit your business at some point. So if you have an intentional exit strategy or unintentional exit strategy, we'll talk about in a minute. However, what you want to make sure that you have is documents in place so that if you choose to sell your business, you've got everything written down and you've kept them. That will save you so much time, money, and energy later on, especially if you've got a good document storage system online. If someone comes to buy your company or if somebody wants to invest in your company, you can give them the login details and say, here you go, here are all my details. And that is honestly so much of a time saver and an energy saver. Y stands for your values. I always tell people I've got 3 principles in businesses because I can't actually remember all 6 of them at any one time, but this is the one I always remember. Never get into business with anybody that you don't trust. Sounds like an obvious principle, doesn't it? But time and time again, I get people coming to me and saying, I don't really trust this person, so could you make this agreement watertight? And I'm like, just don't get into business with them. Whatever you're doing, they're not the sort of person you want to do business with. Honesty, integrity, I assume, as part of this discussion, that everybody here is looking to deal in an integrous and honest way. And I also assume, somewhat naively, that everybody you're going to deal with is integrous and honest. Presumably, you're all smart enough business people to know when somebody does not fit your values. But I can't emphasize enough, having a contract in place or having a relationship in place or a partnership agreement or a shareholders agreement in place, it makes no difference if that person can't be trusted. And that's a really simple principle of business. And I know everybody knows it, but it's funny how many times people come and they just want to tie up those loose ends with a document, which actually doesn't help them at all. Well, it gives you a legal right, but it probably won't help. So, the 5th principle is that everything is possible, except the things that aren't. So in theory, in law, and I mean law being a very broad concept and context, everything is possible. So when people come to me and say, I've had people who have managed to buy companies with very little cash actually exchanging hands, because what they don't do is look at what the person did before. One thing that I find in small businesses is we often look to the person to our right-hand side or to our left-hand side or our mates in business and go, how did you do that? Oh, let me do it exactly the same way. Everything is possible and everything is negotiable. So in looking at the business context, I have a principle that everything is possible. I believe that you are able to see lots of different possibilities within those relationships. Everything is negotiable. So the first thing you should do in a document is to circle all of the numbers and know that those are all appropriate numbers for you to be able to negotiate. Many people don't do that. In fact, many people don't read the document, which is the next one, but if you go through a legal document and you circle all the numbers, then you can see where there is room for negotiation. Every word is a negotiation point as well. So, for example, it will say you will do everything in your power, or you will use all your best efforts to do something. If you're the person providing a service, that wording will be used, your best efforts. Your best efforts means that if you're stuck and you're not able to do it, you will go above and beyond what is commercially reasonable for you to do it. So every word within that document, you want to look at and go, what does that actually mean? What legal definition, what does that actually mean in terms of legal language? And then ask the other side. If the other side is looking at that document and saying, I don't really know, I don't know why it says make your best efforts. I just want to make all reasonable efforts. And that's the sort of thing that you want to be looking for. So everything is possible in negotiating, and I guess I'm talking predominantly contractually. Obviously, when I say everything is possible except that isn't, what I mean is if it's illegal, it's possible, but it has its consequences, and that is a higher loss. So, if you're going to do something to cut the corners, or if you're going to do something that is against the law, or it's something that shouldn't be done, everything is possible, yes, but you'll pay the price later. And for one thing that I've seen with business owners, we tend to be higher risk people. We tend to be able to think about, we're a bit faster at moving. Lawyers tend to be a lot slower, thinking through all of the issues. When people are going fast and they're moving through the issues quickly, they tend to miss points. And this is where actually just asking someone else, asking your business partner, what do you think this means? Or do you think that this is a risk that I should be taking on? That's really important. So anyway, everything is negotiable. For those that can't see, it says, read and understand everything. So, shall I move this? Shall I move this? Yeah? So read and understand everything. How many of you in here have ever bought something online and then click that little box that says, I've read these terms and conditions, but not actually read the terms and conditions? Yeah, me too. We've all done it. Why do you think it's important to read the terms and conditions before you click the box?
Because you don't really know what you're agreeing to.
Correct. So I've seen clients who've come to me and said, hey, I've had this credit card charge from this place, and I don't know, all I did was bought this CD for $1.99, and now I seem to be charged I've been charged £30 a month actually at this point for 10 months. And they won't give me a refund. This was one of those where actually a lawyer on the other end of the phone, you can just say, hi, I'm the lawyer for such and such, and they'd like a refund. Okay, yes, we'll give you a refund. Of course you will, because they know that that's immoral. It feels immoral, and that's all about your values. But can they do it? If you've clicked to say you've read the terms and conditions, or you haven't ticked a box, now, I would say, I'll presuppose this. There are consumer rules and business rules. If you're signing something as a business, there are higher rules. If you're signing something as a consumer, then they have to be fairer terms than if you're signing something as a business. But as all of you are going to be signing as a business, it's important that you read and understand everything. So I want to just go through at this point some of the things that may not be understood in a contract. Some of those things that I remember I remember not understanding. In fact, probably for years, as a lawyer, I was like, why do we have this in here? So is that all right if I go through a couple of those terms? They're contractual terms, and it is a little bit dry, but it will help you to be able to, when you're reading through, at least skim the document first. Look out for some of these words. So the first one is indemnity. So an indemnity is a promise from you to them to pay them in the event that they suffer loss. So in order for you to limit your loss in your business, you don't want to be indemnifying anybody for anything, particularly if it's not something that you've done. So look through the contract and look for anything that says indemnity or promise to pay. The second one is limitation of liability. A limitation of liability clause, if you are the person providing the services, so for example, in my agreement to provide legal services, I will limit my loss to the amount that is paid to me in the last 3 months. You should be doing the same if you're providing a service. You should have a limitation of liability in your contract, either if you're providing services or you're providing goods. And you want to limit that loss as much as possible. So, for example, I'm seeing more and more is we limit our liability for the last 3 months of money that has been received by us. So that's the sort of thing. Don't think that you're limiting your liability to the insurance that you have. I have seen contracts that have come to me saying, we don't know where this has come from. It's probably, I don't know if any of you have done this, but have you ever gone to your competitor's website and looked at the T's and C's and taken those T's and C's? Maybe not in this room. I can guarantee you it's standard practice. Someone's probably taken your T's and C's and you haven't even had them reviewed by a lawyer, and it's this constant people taking copies of things that aren't quite right. So you end up having, this actually happened to one of my clients, £1 million worth of liability for something like a £2,000 per year service that they were providing. That's ridiculous. That's disproportionate. You want to limit your loss and you want to limit it as much as possible. So limitation of liability. Make sure it's in there for what you do, for if you're providing any services, and make sure that if someone else is providing those services, that the loss within that, so if it says, for example, we'll limit your loss to the last 3 months paid, you need to work out whether that would be sufficient if you did lose something. Subcontractors, that's a good issue with the subcontracting, because if they're the ones performing the services and it's your client and they screw up and they have limited their liability, you need to make sure that you've limited your liability as well to the customer. So you need to make sure that you have an appropriate level that gives you enough bandwidth, if you like. The third one is law. Now, in your agreements, it will always say English law. Likely, but do check. Not UK law, because there is no such thing. It's the law of England and Wales. And make sure that it says the law of England and Wales and the courts within England. Oh, and by the way, I should probably tell you, a lot of this information is on our website, so you can go to the website and there are lots of articles on this. So you can scribble away as much as you like to get the information down, but don't worry, it's not lost. It is on our website. So England and Wales should be the law. You will want to make sure that it says the exclusive jurisdiction of the English courts. Those are two things that are really important for your own contracts. Why? Because you don't want somebody who signed up to your agreement being able to take you to France and for you to have to pay, let's say it's a client in France, assume, you want having to pay a local lawyer, a translator, somebody who can understand the law in those countries. And so this takes me to my next point, and that is the law within other people's contracts. Have you ever read, when you've signed up to something online, the terms and conditions of something outside of the UK? Maybe not. Particularly if you go to the US. If you want to, if something happens to a service provided by somebody outside of the UK, then you will have to go to their country in order to instigate any proceedings against them. Now that might be fine in a regular context. You know, you click onto Google, you're not really that bothered. If you're buying a $2.99 CD, then it might not be a problem. However, if you do have a relationship with somebody, and particularly when we're talking about licensing, when you start licensing abroad, you want to make sure that everybody, if there's an issue, they have to come back here to make sure, if there's an issue, then it's dealt with in the English courts. You want to go down the road, you don't want to have to jet off and pay travel and expenses and language costs for someone else. So check the language out and check the law of the jurisdiction as well. And then, well, this will take us on to the next bit, but basically with agreements, so read and understand everything. What I would do is read it, skim it, highlight any red flags. Talk to somebody else outside of the contract, whether it's a lawyer or just somebody who cares about your business, or whether you do well, and say, what do you think that this does? Also, ask the other side, because often they haven't had a contract, they haven't had somebody draft it. And so you want to make sure that you're both on the same page and that you're not signing up to something stupid that actually hurts you both. So, I think we're 30 minutes in. I can keep going into the next one, or I can stop now. What do you...
Guys, please, we got to grab a coffee.
Shall I do two?
Yeah.
I'll do two, and then we'll just keep going, because I know it's like early evening, and this stuff is quite intense. You're like, you said it wasn't a law degree, but... Okay. So, this will be a bit more... Okay. So those are my 6 principles. Those are my 6 principles of law, and the things that, you know, kind of foundation. They're the support network, if you like, towards having a decent business and making sure that you're thinking things through. These are really key things to be aware of, or key actions to take. And the first thing is investigate. It really relates to when you're looking through a contract or when you're looking through any document, who are you dealing with? And I have a principle which is ask, then check, then ask again. The asking is asking the other side, who are they? Are they limited liability company? Are they based in the UK or England and Wales? Are they Scottish? Are they just down the road? Or are they based abroad? For me, whenever I'm looking at whoever my clients are dealing with, it's a red flag if anyone's based abroad. Now, that's not to say that they're not trusted because they're based abroad. It's just to say it highlights something to me, and that is, first of all, the jurisdiction and the language, but also because you don't know another law. And so you need to make sure, and because they're not on the ground, unless you visited their office, you don't really know who they are. So the first principle I would say is ask them. Who are they? What do they do? Google them. Google is like God. Find out exactly what they have done before. Who has complained about them? Who has bad-mouthed them? is who they say they are actually what it says on their website? So, for example, a limited company here, we all know what the difference between limited and sole trader. How many people here are limited companies? So pretty much most of us. That's good because we've got a share section, that's good. So limited companies, we need to make sure that in other countries we've got something similar. Limited companies or sole traders, I've seen companies when I've been looking at this investigate who have signed an agreement from their website. So they're like www.abc.com. Now that is not a legal entity. A website is not a legal entity. You want to know who that person is who is responsible for that relationship. And you want to make sure that they are part of that agreement. You want to know who they really are, and you want to make sure that everything you can find out about them, you manage to gather together. So the best place to do that for companies based in England is Companies House Registry. I always go on there. I will download their director details. I will download their share capital. I will find out more about them probably just in that short, just by logging on and giving their limited number. You can find out a lot about them and what they do. You can also find out if any of their directors have been disqualified, which is an important thing. You just want to know the background to what they're doing, and it's all free information. You want to go onto Google, check whether they've got any complaints against them. I would also go to, particularly if it's a big, you've got to weigh up how much you want to look at in terms of risk. But from my perspective, if I was doing a big deal, for example, we did a transaction the other day and it was worth 300,000. For me, I want to make sure that that company is still solvent. And I will check that on the day that I meet them, and I will check that on the day before the transaction finishes. So you can go to insolvency.gov.uk and you can find out a little bit more about them then. You might want to go to the ICO.gov website and see if they're registered for data protection. So that's the who. Are you dealing with a sole trader, a limited company, and where are they incorporated? Now, one of the things that was clear to me, for example, I used to work on big transactions, and one of the countries we were dealing with was Ras Al Khaimah, which is in the Arab Emirates. Now, Ras Al Khaimah you were dealing with the government, and the lawyers out there told us, we can have an agreement if you want, but it really doesn't mean much. The government do what they say they're going to do. They can do whatever they want. So, what are the local customs? Find out the local customs over there. If you don't, you can just speak to a local lawyer by picking up, there's the Legal 500, and you can speak to a local lawyer out there and just say, is there anything that I need to know? Just basic information. Actually, if you just ask a lawyer, they will be able to tell you a little bit about the local traditions and the sort of people that you might be getting into bed with. Are they part of any membership body? So is there any group of bodies? Do they have to be regulated? For example, if I was dealing with any financial services here in the UK, they'd have to be registered with the FCA. So I might go and find out if there are any complaints made against any of the individuals that I was dealing with. I might just look them up on LinkedIn and social media and just know that the people that I'm dealing with are real. I actually had someone last week who said to me, are you actually a lawyer? He was, but he was genuinely asking me because all he was dealing with me was by email. So he asked me for my details for the Law Society so that I could send it, and I sent it over to him. He said, okay, great, because all I could find on LinkedIn was that you were a lawyer, but I needed to know, I needed to get that much more detail. So find out. You'd be surprised how many people don't even look that far. They're like, okay, I've got a contract through, let's sign it off. We want to move forward. So that's investigate. Where are they? What are they doing? Who are they?
I have a quick question.
Sure.
In the US, you can actually look up the bar association to see whether that person is,
correct.
qualified to practice law.
Yeah.
What about here? Who do you go to?
You go to the SRA, the Law Society website. The Solicitors Regulation Authority is the the governing body, if you like, but you can go to the Law Society, you can go to Find a Solicitor, and you can put in the first name or the details. But apparently there have been some frauds with people pretending that they're lawyers And so that was why he was asking me. I was oblivious and slightly offended.
That's good. How about if they are based offshore? Because you say if they're abroad.
Based offshore, yeah?
Yeah.
Anywhere outside of England, I would, yeah?
You know, you will be worried. So how about if they're based offshore?
When you say offshore, do you mean like British Virgin Islands, or do you mean anywhere outside of the UK?
Panama,
Yeah, I would ask a lot of questions. In fact, again, it depends on the risk, you know. If it's for a £2.50 transaction, minimal issues you're going to be asking if their terms and conditions say they're based in Panama. When you start getting to 250,000 or an amount that is important for you as a business, actually we're coming on to material contracts now, but it's like, what is material for you in your business? If it's a material contract, if it's a material amount of money, which if that contract lost, or if this were a fraud, because a lot of this is presupposing there's a bit of dishonesty, but actually it's all about knowing who you're dealing with. That's the simple part here. It's due diligence, and actually this comes from a due diligence. This comes from a due diligence questionnaire, which we would use if we were going to buy a company. And for me, that's the sort of level of, diligence that you want to start getting into the systems and processes of your business to go, actually, when someone comes to buy something from me, I need to know more about them because I want to know what the risks are here. There are obviously less risks if you're taking financial payments through credit card. It really just depends on where your risk lies. But in terms of, I would say, anything outside of England and Wales, it would raise a red flag for me. That's what it would do. And then I would have to go, do I care? Do I care? This is a £20 transaction, it's not an issue. Or actually, this is going to be my livelihood. I need to know more about this. Does that answer your question? Any other questions on that? Okay. Oh no. This one's cheating a little bit. Okay, I'm going to get you to get friendly now with the person next to you. If I tell you, I'm going to tell you what the definition of a material agreement is. Woo! And then I think we'll end on, we'll take a break in a minute. But a material agreement is an agreement in your business that if it disappeared tomorrow, it would cause substantial or irreparable harm to your business finances or to your reputation. Just turn to the person next to you now, introduce yourself if you don't know each other, and discuss what the material agreement might be in your business, because I can guarantee, and so it could be, for example, that it is more than 10% of your annual turnover. It could be more that it would, if it disappeared on you, it could be a key person that works within your business, like me, for example, which if I went, then there would be nothing left. So or it would cause substantial harm. There is one client that I have that probably brings in 30% of my revenue. So if that client goes, what happens? So just turn to the person next to you, introduce yourselves if you haven't done already, and just say, what is the material agreement in my business? Yes, sorry?
Can you just repeat once more what the material agreement?
Sure, let me read it from here. It's an agreement which, if it disappeared, would cause you substantial, irreparable, financial or reputational harm. So basically, it would screw your business. That's a material agreement. And it's really important to know what your material agreement says. So I'll just give you 30 seconds. Any volunteers? Yeah, go on.
I was just going to say, you were saying.
Yeah. Sorry, everyone. Anyone want to share the material agreement? So we've got a.
I was just saying, I mean, like you were saying before, personally for me, I'm going to start a minimal business by myself.
Yep.
So if I'm not there, my whole business is done. You know, if I'm not well, if I'm in a hospital or something, or
Yeah.
you know, that's it.
Yeah, and where's the legacy? Do you have a will? Not to put you on the spot, because most people don't, actually. And we'll come to employees later on, but it's a really serious business. And actually, one of my mentors, his name's Derry Llewellyn-Davis, this is one of his biggest things is, if you get sick, if you die, what happens to your shares? What happens to your business? For example, who can log on to your emails just to even check what's going on? How have you backed up? I mean, we could go into IT and all sorts of security interests here, but absolutely, you are your biggest risk in the business. Anyone else? Yes. Oh, sorry, 1 second.
So can I just clarify, agreement, is it agreement because it's a document?
Not necessarily.
Because
It can be a relationship so for example, when you're working, you do have an agreement with the company. The company is a separate legal entity. But so do you have an agreement, a particular agreement that you were thinking?
No, I was just thinking, major client, would that be a
Yes.
material agreement?
Definitely.
Because it's a relationship.
Yes. So if you're working for them and you don't necessarily have something in writing, well, this would be my point with know your material agreements. So there are 3 points that I would make with material agreements. Know what they are, identify what those are. Make a list of those material agreements, and mitigate the loss of losing those agreements. Now, some people would say that's about getting a wider client base, for example. Some people would say it's about insurance. If it's you yourself, and I have to qualify this, I'm no insurance expert, but it might be getting critical illness. It might be just making sure that, particularly if you've got children, it might be making sure that you've got some sort of insurance that if something happens to you, you've got some cash that comes into the business, or if something happens to you, you've got some money that can buy out the shares of someone else. So really that's material agreements, and material agreements are going to be so different for each business, but I want to just impress upon you the importance of the material agreements. And actually, this is what will give your company value if you decided to sell it in the future. It's those material agreements, and having them in writing is so important. Making sure those now, not necessarily with yourself, you don't necessarily have to have a relationship with your own business in writing, but having those material relationships with key employees, for example, in writing, so that they don't just disappear. Really important. Making sure that any consultants who work for you and you think, if this person dropped me tomorrow and went off and started earning the big bucks in corporates, you want to make sure that that person is committed to your business. You need to just make sure that contractually that material agreement can't just break down. So I think it's time just to take a short break. Well, what I'm going to do, because I realise that actually in a lot of this, I'm not going to be answering a lot of your questions, because I just looked at the list and there's quite a long list of questions that need to be answered. So what I want to do is get through these and get the basic premise here. We'll come to one or two of the issues, and then opens it up for questions, because I think what happens with most people are the specific questions that are like, what I really just need to know is this. And so hopefully that will answer some questions in that way. So my third principle is help. Love it or loathe it, lawyers are supposed to be here to help. They're supposed to be there to point out the issues in your business, to be able to see those risks. And actually, a lot of lawyers that I know, if you pick up the phone to them and ask them questions, they will be willing to support you with the questions that you have. They may charge you later on, but one of the things that I would say is, find somebody who can explain things to you and somebody who understands your business. Get them to work on a fixed cost basis and be really, really clear about what it is that you want to achieve. One of the things that we found is that one of our most popular articles is how to instruct a lawyer. because people just don't really know. And you know what ends up happening? I mean, I said it earlier, signing a blank check is not something anybody wants to do. And a lot of lawyers charge by the hour. And then you go, well, how much will it be? It's a bit like bringing in a builder, like, so how much will my bathroom cost? And they're like, well, we charge by the day. And how many days will it take? Well, that depends on the issues. Be really clear on what those are. And one of the things that I will suggest to you all, there's a little blue box at the back there. If you put your business card in there, or go through an entire health check on your business, totally complimentary, no obligation, and we can get to understand all those little nuances within your business to go, actually, you probably do have more material contracts than you think, or there are those issues that come up. But that gives you a place to start from to say, right, these are, it's like, this is what I need to get done. And you can instruct whatever lawyer just to say, this is what I need to achieve. I had someone actually call me this morning who said to me, all I need, I've got the agreement, all I need are these 3 clauses. And I said, okay, well, I'm going to need to know a little bit more about your business. She's like, no. All I want are these 3 clauses. And I thought, fine, I'll just give you those 3 clauses. You know, there was no, and I think she explained later that she'd had problems with lawyers in terms of charging through the nose for stuff they were going to do. And I did say, well, I do work on a fixed cost and none of the stuff that I do up front is charged. But I get it. Like, I am a small business myself and I don't like being charged by the hour. Give me a fixed cost. Even if it's more than the other person thinks is by the hour, I would prefer a fixed cost than somebody to say, this is what we're going to achieve and this is how much it's going to cost. But ask and speak to people and ask those questions. And that's what we'll do at the end of today. This was asked earlier. Other obligations.
Sorry, so what you're saying is rather than £50 an hour,
yeah,
they charge £300.
£50 an hour?
Whatever.
What lawyers are you using?
For the whole,
yeah. So instead of you...
of time.
Yeah, exactly. So you can say, I need... Yeah, so actually I would even go to what is it you want to achieve? That was what I would always ask. What are your biggest issues in this contract? So let's just say, me and my business partner want to enter into a shareholders agreement. We want to both own 50% of the business. I want you to tell us the questions that answer the questions that you need for us to know so that we can get clear and give you clear instructions on what it is that you need to produce. So it's almost like a phased approach so that once they come back to you with some questions and you can get clear then on what information do they need in order to produce that. And then you can do that to 2 or 3 lawyers. You know, how much will it cost you to do this? I want a fixed cost. Are you talking, £1,000? £250? And most lawyers, by the way, work for about £250 an hour. I mean, that's a pretty standard amount. So you kind of want to nip it in the bud quite early and just get people not thinking, getting them thinking commercially. It's like, well, this shareholders agreement is not worth anything right now to us, but it's about us mitigating losses later on. So it might be worth us spending £1,000 on. Certainly not worth spending £15,000 on. So we need to find a suitable amount for us to get what we need to achieve, and that is that we have a proper relationship. One thing that is clear for me is people using, online documents. I know a lot of people that use them and they're super useful if you know what you're looking for. How many people have used them and don't really know whether what they've used is correct for what they want to achieve? I know those sort of things. I look at them like NDAs, for example, confidentiality agreement. And I'll go, okay, I've got a confidentiality agreement from this downloaded. There are like 6 different types of confidentiality agreements, some which are more detailed than others. Sorry, does that answer your question? So you're saying, yes, so so basically it's instead of telling me it's going to, I work for £250 an hour and it will be around 3 hours, it's like, yes, but how much are you going to cap it at so that I know exactly how much I'm going to be spending. And actually, whilst you're doing it, can you also do X, Y, and Z to make sure that you've got everything consistent within your business? For example, we'll come on to shares in a minute, but if they're going to do the shareholders agreement, can they do all the company secretarial stuff behind it? So can they kind of incorporate it in a package and put it all together? So other obligations, I'm going to leave this out to the group really. What other obligations, I think you mentioned it earlier, are there that we'll do a quick round robin on? So other obligations within business. I'll start us off. Data protection. So data protection, anyone else? Insurance, brilliant, yeah.
If you're selling goods and then liability, if someone's injured in the goods or...
Sale of Goods Act, good point, yeah. I'm going to put these up. Sales of goods, data protection, tax. Anyone else?
Debts.
Sorry?
Just debts.
Debts. So I would say debts is like, what would I say? That could be credit. Yeah, debts and credit. So within business, there's obviously lots of obligations. For me, the main ones that small businesses have, particularly if they're dealing online, is data protection. If you're getting names and addresses, then if you go to ico.gov.uk, that's the Information Protection Commissioner, ico.gov.uk, and on there you will find a list of... You'll be able to do a test, basically, to say whether you've got to register for data protection. So how many people here actually take people's names, addresses, email addresses, personal information from people? So not that many. Okay, no, yeah, all right, a good number. That's great. Yeah, so go to the Information Commissioner's office. I'll tell you the best place to get tax information, HMRC. They're like the best library for information and just finding out about stuff, you know? You can phone up people, and the same with the ICO. You can phone them up and ask them for questions on these things. There's BIS, which is the business, oh my God, now I'm going to forget what it is. Business, enterprise, I'll come back to it. DTI, Department of Trade and Industry. So those, business skills, innovation and skills, bis.gov.uk. It's a government website, and it's got everything you might need to know about starting a business. Consumer stuff, so consumer stuff wasn't up there. If you're dealing with consumers in your business, there are particular things that you need to look at, and that you will find on BIS website or the Department of Trade and Industry. Great websites where you can get all the information that you need. Another thing came to me just now, data protection is the ICO. This is HMRC. Sales of Good Acts will probably be DTI. Company's House. So Company's House, putting the records up there, doing your shareholders agreements. You can do it yourself. I mean, most of the time it's an accountant that does it, but that is an easy way of looking up people, for number one, and finding out information about them, but also in knowing what the obligations are in terms of you having to file something, so you don't have to instruct a lawyer. When you do want to instruct a lawyer, which I think was one of the questions asked, when do you instruct a lawyer? My suggestion is when the risk of the loss and the probability of the loss are higher than you can bear. So if, for example, it would cost you, first of all, a conversation is always a sensible thing. You can always pick up the phone. So it will never cost you just to get in contact with a lawyer and just speak to someone and say, I'm thinking of doing this. What do you think? Know that lawyers will always take the more commercially risk approach. That's just the way that they're built. That's just what they do. They're the black hat if you know about the different hats. They're the black hat, they're the thinking hat. They really will dig up the risks. But if you know in your mind, for example, that you're going into, if your business is worth 100,000 and you're going into something that's worth 10,000, that's probably a medium risk for you. That's probably a risk that you can incur. If you lost £10,000, it would hurt you, but it wouldn't be the end of the business. But 50,000, that might be more. And so that's what I would look at. And if particularly you don't understand what's going on, or if you're thinking that there's something not quite right, then I would not necessarily instruct a lawyer. I would speak to a lawyer and understand their thoughts on it, because you'll find a lot of this stuff you can work through. You can work through just by talking it through and finding out what the risks are. Employment. Now, employment is the only. Well, it's not the only area, but it is a key area that I would say get some support on. If you're bringing employees in, get somebody who knows about employees. That, to me, it's one of those legislative, and your accountant is a good person to do that. You don't necessarily have to have a lawyer. Your accountant can deal with PAYE, they can deal with the national insurance, and you can find a relatively simple employee contract that you can download. But if you're starting to grow your business, just getting some simple HR advice, and there are hotlines, by the way, that do HR, they do HR guidance, which you can pay a fee like £15 to go to be part of, and that's really, really useful for those other obligations.
What about if you're using freelancers and just paying them without?
Good question.
Is that
Different, yes, but it is relevant, and we'll come to that down here. And the only thing that I was going to say is advertising. The CAP code, it's called, CAP code, sets out your obligations relating to marketing. So you can't mislead people, for example. There are certain things that you can't advertise. Now, this is mostly for larger companies, but it's worth getting your head around and just understanding the sort of things, particularly related to consumers, that might be useful for your business. It also sets out, or particularly that marketing obligations and how you can market, email marketing, opt in and opt out, and getting consent from people. How many people don't know about the requirement for consent for email marketing? How many people email market here? No? A little bit, yeah. So there are particular consents that you have to get from people when they've got to opt in. And actually, we're quite fortunate in that most of the things like MailChimp or Salesforce, they have that little bit at the bottom that says unsubscribe. But you just want to make sure that you're not going to get caught out. Now, another point, and I guess another principle is, what are the risks? Like, if somebody makes a complaint about you for continuing to be on your list, what's the worst that can happen? Are they going to spread your name all over the internet? Probably not. It's probably a low-risk thing. But you do want to make sure that, there's diligence within your business and that you're thinking these things through. Okay. We touched on this earlier. So I won't go back over it again. And that's unintentional exit. One thing that I find is that companies are often ill-prepared for exit. Exit can mean to me two things. One is intentional exit. So you you sell, you retire out of your business, you decide no longer to work for the business, or you only work for the business on your own terms. That's usually an intentional exit. You've planned that. Unintentional exit is everything we discussed earlier. You die, you get critically ill, your company goes under, actually. That's an unintentional exit. And preparing for both are really important. So in terms of preparing for unintentional exit, we discussed things like making sure you've got wills in place. But simple things like making sure your business partner or your key employee knows where the passwords are if something happens to you. You might want to look into insurances there's like shareholders protection insurance that you can look at. There's also key man insurance protection that you can look at, although that's usually for another person in your business, not yourself. Particularly if you have children, that is really key, because you want to make sure that if something happens to you, there is some sort of blanket. You've got some level of protection. Intentional exit are all of the things that we've discussed in the in-house lawyer section, really. It's about making sure you get things in writing, making sure you don't have any critical risks, making sure that you've read all the terms and conditions and that your business isn't set on shaky foundations. An intentional exit during that time depends on what level the person who might be buying your company, but imagine they're buying or investing into your company. they're going to want to know that you've been diligent in what you've done, and they will dig up any issues in your business and any gaps and holes at that point. And either you'll have to fix them and pay some money to fix them, or you'll have to not fix them and you'll pay by the price being reduced for the business. So that's the key thing with the unintentional exit. How many people did I hear have a plan? I saw one, I remember. You've got an exit plan. You've got an exit plan. Great. What about the rest? Is it just that you're not going to be leaving your business? Or it's just not something that's come to your mind? I'm not looking at you particularly, but you just caught my eye. Okay, this one, so I do a lot of health check questionnaires. I've done about 100, probably more. And 80% of those people are in limited companies, 20% are sole traders. Of those 80%, 100% of that 80% have issues or risks associated with their shares or shareholdings. And that's either because they're looking to get investment, or they have got investment, or they've given away shares too early. And I cannot, it's one of my, I guess I would say pet peeves, but it's also something that I see so often that I cannot impress upon you enough the importance of this next section with the structures and shares. And honestly, this is one of the things that I see most. And that is just avoid giving away shares. Avoid it. Keep your equity. Try not to, whatever your relationship is, and I know most of us, it's cash poor, therefore we give away what we have, and that's the equity. But what I find too many people doing is going, okay, well, I need my website, so I'll give them 5%. Just like that. I'll give them 5%. What you find when people give away shares is that you can't get rid of the shareholder. If there's a dispute in your business, it's a little bit like, I don't have any children, but I imagine it's a little bit like, you've got two parents and you've got this baby and you've got to unravel the DNA to get back to where you were. And it feels just as painful when people come to you and say, no, we didn't get a shareholders agreement, but I gave her 5%. Well, yeah, but she's just my wife. I'm like, I know, but just don't give it away. I know it feels nice, and I know it feels like you're including people. So there are several things that I'm going to say around this. So first one is value it properly. Know how much you are actually giving away, and know that any shares you give away, know that it can cause more problems. So the administration in dealing with the shares may cost you double of what you think you're giving away. So that's number one, is value it properly. The second one is, don't assume everybody wants shares. I had somebody come to me saying, oh yeah, I want to give my employees some shares. They don't want shares, they want to be paid more, that's what they want. And unraveling them later on when they decide to leave will be a pain in the backside. So don't assume that that's what they want. Be aware of 50-50 relationships. If you have two people equal in a relationship, at some point you're going to disagree. So who is going to be the person making the decisions? Who's going to be the chairman, if you like, of that relationship to say, no, we're not going to do that, or yes, we're going to do that, we disagree now. And what's going to happen? How are you going to unravel that relationship if you have to? That needs to be put in a shareholders agreement. What are you going to do about sell and transfer? Can this new 5% shareholder sell to his best friend or to a competitor? Or can they sell at all? If you don't have a shareholders agreement in place, they probably can. So all of these things, it's just, before you do anything, before you get investment, before you give away shares, really give it some thought, because I've seen some really innovative ways of not giving away shares, giving away profit sharing, for example, or revenue shares, or being able to say, well, look, you and I want to work together, you'll take 50% of the profit that comes from this business. Really think about the numbers, not just about the ease of just giving them a couple of shares and hoping that it's okay. How many here have more than one shareholder in your business? Okay. And was that through investment or was that through something else?
That was just through me and two others that set it up, so it was a joint venture.
So it was it was deliberate in the way that it was set up from the beginning. And yourself?
Yes,
same.
But I'm an accountant, and I can just say everybody should listen to you because I see it every day.
It's so painful.
A lot of businesses, and they just say they've got a friend that had in a pub and they decide they're going to start a business, and this happens so often. Give 50% shareholding, and it just causes nightmare later on. You can just see where it's going to go wrong. Yeah. On the first day, obviously, you can't,
Yeah, you see it, don't you? But you're like, come on. And people say, well, I had somebody say to me, I just want everybody to be involved with my business. And I'm like, that's great. Set up a community interest company or set up something that doesn't involve shares, because this is a pain. This will be a pain for you. And I just don't be too quick is my suggestion, unless you're getting in right at the beginning. But even if you're getting in right at the beginning, make sure that's documented. Make sure you know what's intended. What you don't want is, and that's when it becomes really important with wills, you don't want your business partner, something happening to him, and then suddenly you're in business with your business partner's mum. Yeah, woo! I wouldn't want to be in business with my mum. That's what I was going to say. All right, this is the last bit, and I think this will answer the questions. It's not strictly employees, actually, because we kind of covered the employees stuff before, but those people that are working for you, and I know many of us, we won't actually be having employees yet. It would be consultants. So if you don't have an agreement in place with a consultant or somebody that is doing work for you, who owns the intellectual property or who owns the rights to what they are producing? Correct. Yeah. So if at some point they have done some work for you, and this was a classic one that came up for me, was somebody whose entire business was around software. They had outsourced it without contract, and that relationship actually was solid at the time. But unless that person had got into they hadn't got anything in writing to say, all of the copyright and all of the ownership in that would be transferred back to him. And they didn't have a consultancy agreement in place when they started. That's a massive risk. That's a huge risk. In fact, that underlies everything that business would have been valued at, because they wouldn't have owned the IP. Sorry, yes?
Anybody who has written a lot of code will come out of the woodwork to claim share.
There you go, yeah.